No surprise anymore. Our wonderful friend Arthur Crooks is back. And I have had lots of phone calls from all of you out there who have either asked for copies of the DVD, or DVDs, I should say. We've done many shows now. Or asking me, when's he going to be on again and what's his next topic? So here we are again, and we have another two-parter for you. So the first one we're going to begin is on guardianship and conservatorship. And this is kind of that topic that we've sort of been leading up to, that if you don't put all those ducks in a row that we've talked about, this is where you end up, folks. Without further ado, Arthur.
Thank you, Barbara. And that's an excellent lead-in. In past shows, I've talked about the basics, the basic documents being a power of attorney, a healthcare proxy, living will, and HIPAA. And these are documents that you do while you're capable and competent, wherein you name someone, for instance, in the power of attorney, who would handle your financial affairs if you were incapable of doing so. And the healthcare proxy is a document wherein you would name someone who's going to make your medical decisions if you were incapable of doing so as determined by your treating physician. However, as often as I tell people, everyone should have these documents in place. Statistics still show that maybe 70 to 80% of people don't have these documents in place. So what happens if you wind up in a situation where you do become incapacitated and have not done these documents and are incapable of either carrying on your financial affairs, or the doctor feels you're incapable of communicating with him about your medical issues? Well, then it's off to the probate court, and you will be introduced to the wonderful world of guardianships and conservatorships. And the reason this program is called Guardianships and Conservatorships is a little history to this, which I'm going to go into. If we had done this program a few years ago, I probably wouldn't even be talking about conservatorships because it was very infrequently used. All of the matters that we would be dealing with would be dealt with under the guardianship side of the court. However, let's go back a few years. There was, going back several years, for the past 20 years, there's been a committee working on reforming the guardianship rules, regulations, and law. They were quite antiquated. A lot of things didn't make much sense, and they were trying to update it. Well, about 2 years ago, 2.5 years ago, the Boston Globe ran one of their Spotlight series. And this happened to be on certain abuses which were occurring at the Mass General Hospital and the Suffolk Probate Court. And what these involved were, and again, I can't recall the specifics, it was a while ago. Quite frequently, hospitals have people in them, let's say they're older people who don't have healthcare proxies or powers of attorney, and they may be deemed or perceived as incompetent. There's no one to act for them. So in order to have someone to act for them, the hospital or their attorneys will seek to have a guardian appointed. And quite frankly, what was happening up in the Suffolk court with Mass General was they were having guardians appointed in a pretty speedy fashion and kind of rubber stamping the guardianship so that the patients at the hospital could be moved out and placed rather quickly in nursing homes. So you had people, elderly people, one day they're in the Mass General and the next day they're in the nursing home going, how did I get here?
With no appeal process.
Well, none that they would be aware of. Right. And so this story broke. It ran for 2 or 3 days. In the meantime, the perfect storm was forming because the long-standing chief judge of the probate court was getting ready to retire, and we had an incoming judge, and she was looking for something to put her mark on, and this was ripe, and she had already been doing some work. So the Uniform Probate Code, which is the one that's been in the works for 20 years, was supposed to have gone into effect this year. As a matter of fact, I think we've talked before when we talked about wills, that the new probate code having to do with wills was supposed to have gone into effect this July, but that's been postponed to January of 2012. Just the opposite happened with the guardianship rules. As a result of the series in the Globe, as a result of these perceived problems with guardianship and abuse of the system, it was dictated, so to speak, that these rules would go into effect immediately back then, and they did go into effect July 1st, 2009. So the whole system changed drastically. And the key to the changes were to give much greater protection to the incapacitated person, which is what we call the ward. We used to just call everyone a ward. And a whole new set of rules and regulations came into effect, and it's vastly, vastly complicated this area. When I first looked at the new rules and we started doing these applications under the new rules, I said, this looks like it's going to be about 3 times as difficult, 3 times the paperwork. Well, it's not. It's about 10 times as difficult, 10 times the paperwork. How do lawyers get paid? They get paid by the hour, right? So let's go back and compare, having done those very simple documents, the power of attorney and the healthcare proxy. If those are in place, for the most part, with some exceptions, you're going to avoid the necessity of going over to the probate court. Your family's going to be spending an awful lot of money to get the guardianship, which eventually will be coming out of your pocket if you have any funds. And after the guardianship and or conservatorship is obtained, the reporting requirements and the checking up on the person who is the guardian, those go on forever. I am now guardian for several people, and I learned, to my regret, that they do enforce these reporting requirements. And for the first time since college, I had several all-nighters last week pulling together some overdue reports, because it's all in the new computer system called Mass Courts. In the old days of just shaking your hand when you became a guardian and you're never having contact with the court again are over and done with. So I'm going to harp a little more. Get those basic documents done, because if you don't have them, this is the only alternative. And then the court steps in and the court will take over with all the new rules. So what I'm going to do as I go along, legally, something that's only been in effect less than 2 years is like brand new. We're still having seminars. They're still tweaking the system. They have all new forms, which every once in a while have to be changed. You have to be abreast of all the changes to keep up with the proper way of doing things at court. So,
2 questions,
yes.
Arthur. What kind of people would be deemed needing a guardian or conservatorship?
Okay, very good question. The key document when you do a guardianship, other than applying for it, is something called a medical certificate. The determination as to whether someone needs a guardianship or what level of guardianship. You can have limited guardianships, which is what they prefer, or you can have just a total guardianship. So the doctor, I'm looking at the new form. A doctor, a licensed psychologist, a certified psychiatric nurse, clinical specialist, or, in the latest amendment to this form, a nurse practitioner can fill out a medical certificate. Now, before the new law came into effect, the medical certificate consisted of 1 paragraph. It was a narration. Sometimes I'd help the doctor with them. So-and-so suffers from what is perceived to be Alzheimer's disease. She cannot do the following activities of daily living, and in my opinion, she cannot make reasoned decisions about her care. Something to that effect. They wanted you to have a little something down there. I used to see them just saying, this person's demented, or this person's incompetent, and those would pass muster. Well, as a result of the new law growing out of the situation in Boston, we now have a medical certificate which is approximately 9 pages long. And we go into the complete history of the patient, or as we now call them, the prospective incapacitated person. And this takes a long, long time to fill out. Needless to say, your family doctor's not thrilled when one of these is put in front of them. And there are ratings as to whether the impairment is none whatsoever, mild, moderate, severe, or the person's totally non-responsive. And then there are places that have to be filled in with narration. And this goes on and on and on and on. And
no more rubber stamping saying that they're just demented,
no
because
more,
you've got to prove now.
No more.
In what
You have to prove. Everyone is presumed to be competent until you prove otherwise. So when this is all done and the doctor signs it under the pains and penalties of perjury, there'll be recommendations as to what level of competency the person has. The judge will look at it and say, I'm either satisfied and perhaps we'll do a temporary for a short period of time, or, you know what, there may be some eccentricities here or some oddities here, but I'm not going to take this person's freedom away based on what I've seen here. I had one recently where the guardianship was allowed for 1 month, and the only power given to the guardian was the ability to control the ward's driving. Other than that, the ward was left with complete discretion to do anything. The next time we reviewed the case, the judge actually made a field trip to the home of this person. And his wife was also in a similar situation. And after he observed the behavior of these people at home, he then agreed that perhaps because of their deficiencies, a full guardianship would be appropriate. But it's a moving target, and at least the judges in Barnstable County take very seriously the new directives that you better prove your case. In the old days of a couple of sentences are long gone.
Well, I think another important piece that's a lot of people don't know is that it can be temporary. You can have a massive stroke and have somebody take over temporarily and then slowly, hopefully, come out of it and maybe have that changed.
Generally speaking, if there's some kind of a situation where you need to have the guardianship in place right away, you can go in, if you present the facts, that we need a guardianship. You always have to file your petition for the permanent guardianship. Doesn't mean you'll ever get there. You also, at the same time, would file a petition for a temporary guardianship, and the court would want it to be in the nature of an emergency. So what you would say is, so-and-so just suffered a stroke, immediate care is needed for decision-making. Remember, this is the person who didn't do the healthcare proxy. If they had done the healthcare proxy, we wouldn't be over there. The doctor would be looking at the healthcare proxy, seeing that the child, for instance, was named, and that would get done. So I have one now that's it's a very, very sad case where a young girl was severely brain injured in an accident, automobile accident. She's only 23 years old. We've gone in on a temporary, and we've now extended the temporary. But it looks as though her condition is going to be permanent. So at some point, we will just go to a permanent guardianship. So to get back to your example of the person with a stroke, maybe we get the temporary for 90 days. That's usually the period of time you get a temporary for. And let's say at the end of 90 days, the person's improving but still needs help. But it looks as though they may recover eventually. Well, we'd perhaps extend it for another 90 days. And if, in fact, the person recovers, can make decisions again, and I had a case like this, then we just don't go to the permanent, and we just tell the court that the purposes of the guardianship have been accomplished, and we ask the court to dismiss it. Okay? So that happens occasionally. More often than not, we're talking about, usually it's an older person going into a nursing home where the likelihood of recovery, say in an Alzheimer's situation, is fairly non-existent. So we will be going to a permanent eventually. But there is a lot of flexibility built into the system, and every time you want to do something, of course, there's 50 forms to fill out. But
the other question is, if you had a person, because we are having our folks today living longer and longer and longer, we've got a couple that are late 90s and one who's over 100, And if they've outlived a lot of their family or all of their family, and they didn't do those documents because it just wasn't something that was done in their day,
Right.
and now they're in a nursing facility, isn't the nursing facility going to need something to have someone help them make a decision?
That's correct. And I experienced this both through, let's say we have someone in the hospital. Let's say this 90-year-old person has been managed to stay at home up until a certain point, and they go to the hospital. The EMTs bring them there, and it becomes very apparent that this person lacks decision-making capacity. There's no family. What will happen is the attorneys for the hospital will take this to court, and they will seek a guardianship because they can't do anything until they have authority. And if there is no family member available or willing to serve, there's a list at the court of people who are qualified to do it. And the only requirement is a suitable person. So then you will have someone appointed who has training and experience in these matters. Same thing in a nursing home. You may have someone that's been there a while. Usually in a nursing home, they're going to be looking for a healthcare proxy because they don't want you in there without someone to turn to. So if this same person who is in the hospital is transferred to the nursing home, the guardian would be making that decision. So they're always going to find a guardian for you. And this is a not uncommon situation where older people, it's the first time they've ever been incapacitated, and they've never really had to use these documents before.
Now, the other one that goes with that is, let's say they were the smart person and they did all the documents, and they had Mr. Jones as their lawyer, and they did it with their husband when they were in their 40s, and did all the proper will and power of attorney and all of that, and now the husband is dead, the children are dead, and the lawyer is dead. Is it no longer valid? They did all their due diligence, but... Well,
the document is still valid. Let's examine them. Let's say it's the power of attorney, and the person you've named, say your spouse is gone, and let's say you've named a child as a successor. That child is no longer around, and the lawyer is no longer around. The question is whether you're still competent. If you're still competent, then we're going to assume you're going to be able to get a new lawyer and redo the documents. The healthcare proxy, once again, would name your primary choice, and in your example would be the husband, and your backup would be the, say, your oldest child. If they were both no longer around and you were still competent, you would probably be executing new documents. Let's say you're not competent, though, it depends where you are. Usually this will be discovered when you're in the hospital, have to go to the hospital. If you're not competent, then you're not going to be able to execute new documents.
Right.
Therefore, the attorneys for the hospital will be going to court to get a guardianship.
That's what I thought.
And elder services will do the same thing. When they have, and I have a lot of these situations where people will call me and say, for instance, there's one that comes to mind. My sister is living by herself in a home on the Cape. We live in Virginia and Washington State. We can't be there. She's doing the following, she's doing this, she's doing that. She has no power of attorney, no health care proxy. Well, I'll look into it. I'll call elder services, I'll call the police department, and they say, we're familiar with her. Yes, she's very odd and very eccentric. However, she's not a candidate for a guardianship. And if she wants to live her odd, eccentric life, there's nothing we can do about it. And if she doesn't want to execute advanced care directives, there's nothing that can be done about it. And unfortunately, well, maybe not from her point of view, I will have to tell these concerned relatives, you're just going to have to wait till a crisis of some kind occurs. She's transported to the hospital or something of that nature. But it's, there's a lot of gray areas here. But if you don't have the documents and you're institutionalized, someone's going to get a guardianship or conservatorship. That's a good time to bring up some of the major differences that have come about. You notice I keep on saying guardianship, then sometimes I switch over to conservatorship. As part of this new law, they've separated those two concepts. Prior to July 1st of 2009, if you wanted a guardianship over a person, that means the court was going to appoint you to take over someone's affairs. It broke down into two parts. There was the guardianship of the person, which is the equivalent of the health care decision maker, which would be the health care proxy if you had it in place. Then the second prong was the guardianship of the estate, which means you'd be in charge of the money. Let's say someone has no money. Let's say they don't own property and all they get is a Social Security check that's fully expended each month. Mr. Macabre's example, so many pounds and pence in, the same amount out each month. Well, there's nothing there. So you may not need that second prong, which was a guardianship of the estate. Well, under the new law, they've divided the two concepts up completely. A guardianship is only of the person. In the old days, meaning prior to July 1st, you had another thing called a conservatorship, which was of the money only. It was very rarely used, in my experience, because usually when someone reached that point, they probably needed a guardianship also. Anyway, yeah. But now it's separate. So you have a guardianship of the person and a conservatorship of the money. So let's say the person who we're considering needing protection has money and medical decisions have to be made. Now, you recall earlier I said it's 10 times the paperwork. Now multiply that by 2 because you have to file 2 complete separate cases. They all have their own petitions, their own paperwork. The only thing they would share would be the medical certificate. And there are specific questions on here going both the guardianship and conservatorship. I'm doing a case right now where the woman is, the doctors and everyone have deemed that as far as a guardianship goes, she's all right. She can manage her ADLs and make medical decisions. But every huckster and scam artist on the East Coast knows about her. And all they have to do is show up and she just gives them the money. Well, what do? If you're a power of attorney, that does not mean you're going to have total control over someone's finances. This is a question that comes up from time to time. And I'll say to people, well, you could just go in and take everything over. Well, I don't want to do that. That would upset my mother. In the meantime, mother's out there doing whatever she's going to do. So in this case, we had to get a medical certificate which just touched upon conservatorship issues, financial issues. So when we go to court, we're not going to be looking for a guardianship. We're not going to take her ability to make her own medical decisions, her own lifestyle decisions. We're just going to take the purse strings and remove those from her hand if the judge agrees. He may not agree. He may say, once again, well, this is rather eccentric, but if she wants to give all her money away, there's nothing I can do about it. Your medical certificate has to show that she's doing this because there's some kind of an underlying reason, almost a medical causation, psychological causation as to why she's doing it.
Arthur, a question we get all the time is, can't I just, if my mom agrees and she's just a little confused about when they call about the fuel bill or the National Grid bill or whatever the bill may be, she pays it twice or she forgets to pay it and they call or what have you, can I just put both our names on a checkbook and I sign them and pay her bills?
That is a possibility, but I'm going to refer back to 2 or 3 shows ago when we talked about mass health applications. You could be getting yourself in a little pickle if you do that. So once again, going back to one of the earlier presentations, think of the teeter-totter. You're doing something that may help alleviate a situation here, but you may be causing a problem at the other end. But the reality is, what a lot of people do is they just have check signing authority. You know, a lot of this stuff is done. I'm telling you what the legality is. What happens in the real world is a whole different ball of wax, okay? But that, a lot of people will do that. What we're talking about is getting to a level, again, where you don't have the power of attorney or the healthcare proxy, where someone is really losing touch with reality. And that's where we go in and get one of these things.
And there's a lot of people that are living out there alone like that are being scammed. We work with the police department every day on people. We've had 3 or 4 in Harwich from the grandfather scams of sending money, and the minute you send that Western Union, Harwich PD, no PD can help get that money back. So
that's correct.
It's important to get the right
remember,
documents.
when we go in for the conservatorship, the way the court views this is you're taking someone's freedom away. If it's guardianship, you're taking away their freedom to make their own lifestyle decisions. If it's a conservatorship, you're taking away their freedom to give the money away to the scam people, to give the money away to someone who paints their driveway with black paint and they want $25,000, because the person is incompetent of making a reasoned decision in that regard. So that's where we're going to go in and get the guardianship and the conservatorship. Plenty of people are taken every single day that has nothing to do with their ability to rationally. They're just being taken, fooled, scammed, whatever. So it's all a matter of degree. Now, some of the things that they've done, and those of us who practice in this field and have for a while, we got to get used to new jargon. And I keep on saying ward, which is the old term, a ward of the state, a ward. We don't use those terms anymore. The person who we seek the guardianship for is going to be designated the incapacitated person. So when you get up and say, Your Honor, this is the prospective incapacitated person, it's a little difficult to get your mouth around that. The person who is going to be under a conservatorship is a protected person. Now remember, in the old days, you'd have one guardianship, 2 prongs, the ward. That would be it. Now, if we're in there with 2 completely separate matters, a guardianship matter and a conservatorship matter. Now, remember going right back to the beginning of why these new rules came about. It was to afford greater protection to the person who's going to be the subject of these proceedings. And the way you do that is everyone has to be noticed on everything. You have to serve in hand notices to the prospective wards. I'm going to call them that. It's easier to pronounce. And you have to give notice to anyone that's an interested party. And something else you have to do is, in any given case, the judge can appoint a lawyer to represent the person. Under the old guardianship law, that was only done in a very limited number of cases, which involved the use of certain medications. Now it can be anyone that can have a lawyer appointed for them, which brings up the interesting question, who's paying for these lawyers? Well, if the prospective protected person has money, guess who's paying for that lawyer? It would come out of their estate. And if not, the state pays, and you pick up the paper every day and you hear how strapped governments are for funds, but here's another situation where the state will be paying for a lawyer. The other thing is the prospective ward has a right to be present at all these hearings. Logistically, in the past, this has presented problems. And when I first heard this, I said, you know, the court might start looking like the waiting room over at the emergency ward. And I've seen that before. Years ago, we had to bring someone to court on a gurney. But they have that right, but the lawyer acting for them, if one is appointed, is generally going to waive their appearance if it's an impractical matter. The 93-year-old woman in a nursing home with advanced Alzheimer's, she has a right to be there, but whether that's going to serve any practical function, I don't know. We have other people that want to be there, and they will be there, and the judge gets to observe them, which can be very helpful, especially in close cases. That's why the judge in the case I was talking about earlier took a field trip and made a home visit, which was quite helpful to him in making a determination. So, right to be present. I think I already mentioned the fact that the goal of the court, if you have to have a guardianship, is to make it the least restrictive guardianship possible. So when the law was first passed, the idea was that these would all be limited guardianships. We'll fashion them and we'll limit just to the particular deficiency that the person is showing. The reality is 95% of these guardianships are still total guardianships. You go in and you take over everything. Now, here's the biggie. There were 2 or 3 major changes, but this is the one that's caused the most problems and the most controversy. If you have an incapacitated person, an incompetent person, and they're going to go into a nursing home, you cannot place them in the nursing home short of having something in a power of attorney or a healthcare proxy without a guardianship and specific permission from the court to do so. And that includes the 1-week rehab stay for the stroke or the hip operation. This has caused chaos with the nursing homes because they already have their books examined, so to speak, by their auditing agencies to make sure, for instance, those special guardianships I told you about earlier involving special medications. If a person in a nursing home is taking those medications, they have to make sure that they have either a healthcare proxy that covers it or a guardianship which covers it, and we call those Rogers guardianships. You may have heard that term. Now we've added a new one on. So when they come to look at the books and they see, oh, Mrs. Jones was admitted in October of 2009, on what authority was she admitted? And if they can't show anything, then they better have a guardianship wherein that authority was allowed. And this is causing a lot of problems. Let me mention something else. That medical certificate I talked about, you basically need a medical certificate to do anything significant. Anytime you want to petition the court to change something, you need a medical certificate. They're only good for 30 days. And invariably, you file your paperwork, and by the time you have your hearing, it's on day 32. Guess what? You got to get the doctor to fill out another 9-page certificate. However, this was just recently changed because, needless to say, there's a lot of pressure coming back. Now what we have as of November, if you have a medical certificate that's been completed, and it's quite a lengthy, complicated document, we now just have something called an affidavit, wherein the doctor says, nothing has changed in the last, I'm not sure if it's 90 days or 30 days. Nothing has changed since I filled this out. So this is going to be great. There's some thought of maybe making the medical certificates good for 90 days, which brings me back to the admitting to a nursing home. The 3-day rehab stay, the 1-week rehab stay, yes, you need it. I have heard that they're going to try and change that to make that only applicable to stays exceeding 90 days in the nursing home. So if you're coming back from your rehab of your surgery or your stroke and you're going to be in a nursing home for a month, we're not hopefully going to have to trot off to the guardianship court if you don't have other paperwork in place. So that I've heard is going to change, but I haven't heard anything about it yet.
So Arthur, on the kind of guardianship, you have guardianship go into place, but now you've got the person with the psychotropic type of medicines or the ones that put that other Rogers on. So is that a dual? You have to have the both of them in order to have that kind of person?
What you're doing now, we start with our guardianship. That's that's the basic unit, and everything else is an add-on. Okay.
So the Rogers would be an add-on because of the meds?
Well, let's say going in, we knew the person was taking Zyprexa or Risperdal or Seroquel. These are basically antipsychotic medications, but they're widely used in nursing home settings because they have effects on people who are delusional and can calm down and reduce the delusions. So if we're going in, we will fill out the form, and there's a box you check off. Is this person going to be taking antipsychotic medication? We would check the box off. Then in addition to the medical certificate, we would need a treatment plan from the doctor who's prescribing this medicine. That's another 6-page document. So people get the medical certificate and the treatment plan mixed up. The medical certificate you absolutely have to have. If you're using these psychotropic medications, then you need the treatment plan. You check that box off. Automatically, a lawyer is appointed. That's automatic that a lawyer gets appointed. And then we're going to have a hearing on both the guardianship and the use of the psychotropic medication. And I could spend probably a whole session on just Roger's guardianships, but we're not going to do that. But here's one other thing I want to mention that grew out of the new guardianship law. In the old days, when you filled out a guardianship petition and you turned it over, there were 3 little boxes that you would check off if you were going beyond the basic unit. That would be, is this person going to take psychotropic medication? If that were the case, you'd check it off, special permission. The second one would be, is there any prospect of this person being admitted or committed to a mental health or mental retardation or mental health facility? If you were going to do that, in other words, if you were going to ask the court permission to place someone, this is not the nursing home, this is the state hospital or something called a geriatric psychiatric unit, which they have in the hospitals off Cape. You need special permission. Well, guess what? To make things even more complicated, you still need special permission to do that, but the authority to do that is no longer in the probate court. It's in the district court. So if you need everything, make that a guardianship with everything to go, you need a guardianship, number 1, in the probate court, a conservatorship, number 2, in the probate court, then walk across the parking lot to the district court and file a petition to commit, okay? So for lack of having your basic paperwork, you can have 3 court actions going at once, and that meter will really start clicking over, okay? Now, in my healthcare proxies, I think I've alluded to this before, and a lot of practitioners do this. We put all of these things in there saying, we hereby give our proxy the authority and permission to give us antipsychotic medication, to admit or commit us, and I have now put in, and to put us in the nursing home if need be. The third one used to be extraordinary medical authority, and that was anything that went beyond the ordinary. The gray areas, brain surgery, amputations, electroconvulsive therapy, all of those you used to need permission of the court. Having a splinter taken out, having a flu shot, you didn't need special permission for that. So again, that was another major change. I think I alluded earlier to the fact that once the guardian is appointed, it's usually going to be, if it's a marital situation, it may just be the spouse, if the spouse is competent. You have a situation where you said that you may have 2 people in their mid-90s, naming one to be the guardian, that may not be practical. So you may be naming a child, etc. Now, in the old days, remember the old days prior to July 1st of 2009, you would be appointed guardian. You'd get a nice little piece of paper saying you're the permanent guardian, and you'd probably be told, oh, by the way, you've got to file a report once a year. And that had the effect of the tag on the pillowcase, do not remove under penalty of law. It was never enforced. Under the new law, as I had an object lesson in last week, getting those reports in now is enforced. You have a 60-day report. These things are about 10 pages long. You have to file one of those. Then you have to file a yearly report. If you're the conservator, you have to file an inventory, you have to file an accounting, and you have to file a business plan if the court so requires. This gets very, very complicated. These forms are very, very long. So the front end of getting a guardianship conservatorship has been vastly increased, and so is the back end, because now the guardian, and what will happen, as happened to me, you'll start getting little notices, where are your reports, where are your reports, and then finally you'll get a little notice saying, you will be appearing in court on such and such a day to tell the judge why you didn't do your little report. And to people who are getting these papers, they look at them and they have no idea, what they are. So, mandatory monitoring. They're keeping an eye on you when you're acting as guardian. You also have to be bonded. And I think we may have talked about this earlier. All a bond is a promise to the court that you'll do something, you won't run away with the money. As a guardian, since you have no control over the money, you still have to be bonded. The amounts you're going to be bonded for are zero, but you still have to tell the court, you're giving them your bond and your word that you're going to do the right thing. If you're the conservator, you have to figure out, by way of doing an inventory, well, how much is involved here? They own a house. You may not have to bond that because you need special permission usually to sell someone's house. That's called a license to sell. The little boxes for special permission, there's about 25 of them. And we could spend another 2 hours talking about all of those. Because to protect the protected person, just about everything you're going to do, you have to ask permission. And quite frequently, that will engender the court appointing an attorney for the person or another person who's called a guardian ad litem, which is an investigator for the court, who's usually a lawyer. And guess what he or she does when she's done with the work? Another bill, okay? So this is the type of thing you're getting into. One good thing that came about is that lots of times you'll have people under conservatorship that don't have wills. And in the past, you could not write a will for someone as a guardian. You could accomplish it by doing trusts, etc. But now you can actually seek to do a will for someone. And you have to prove to the court why you're doing it the way you are, or you may want to change a will. Something very, very good that happened as a result of the new guardianship law, and it was kind of tucked away. The power of attorney law was revoked in its entirety and readopted with a different designation. This has caused some problem with people with older powers of attorney that reference Chapter 190, whatever it was, because that doesn't exist anymore. The power of attorney that a lot of attorneys used had always just used the language. This is a durable general power of attorney, good through any incapacity up until death. That's what a durable power of attorney is. What this new law did, as far as the power of attorney goes, is it now states that a power of attorney cannot be turned down because it's too old. That used to be a favorite of the bankers and the insurance salesmen. But as I probably mentioned when we talked about powers of attorney, there's nothing that mandates a banker or someone has to accept the power of attorney in this state. So if you have an old power of attorney, 8, 9, 10, 15 years old, and the banker looks at it and turns it down, he's just not going to tell you he's turning it down because it's too old. He's going to say, I'm uncomfortable with this document. Because under the new law, he can't say that he's turning it down because it's too old. So that was a good thing. But I'm still telling people, don't take that to the bank, so to speak, because there's still a way around it. Something else that is extremely important, we talked about it when we talked about powers of attorney, but I'm going to mention it again. When you do a power of attorney, you have the ability, and I always urge people to do this, of naming the person you would want to be your guardian or conservator if we ever went to probate court. You can have all of these documents in place, but circumstances can come up where we're going to be going over there anyway. And lots of times that can be a family fight, or it could be something you really have to get done financially and the banker won't accept your documents. Then we're over there getting a conservatorship. So one of the first questions they ask you on these guardianship petitions is, does the prospective ward have a power of attorney? If so, did they nominate someone to be their guardian? So if this is a battle between the kids and you've nominated Susie to the exclusion of everyone else, 99.9% of the time, that's who the court's going to appoint. And people going in knowing that might back off a little bit. Same thing with your healthcare proxy. Now, another kind of little technical thing. A guardianship does not automatically overrule the existing healthcare proxy. If you get a guardianship, the healthcare proxy is still in force. It could be someone else.
I didn't know that.
Yes. And if that's a problem, you got to go and ask to have that healthcare proxy removed. Okay? That's a very important item, because the conservatorship is just the opposite. The conservatorship automatically repeals any existing durable power of attorney. So those things you want to keep in mind.
So if you didn't turn in those reports and you got the notice, not you, but if a person didn't turn in the reports, let's say I was for my mother and I'm older myself and I didn't really know what they meant and I just kept throwing them away or deleting them if they came by email, can they actually revoke my power? They
could. Let me tell you a little something about those reports. If you didn't do them, you'd be joining me out in the stocks on the town common. The reports are actually read by a group that, it's my understanding, they're primarily retired lawyers. So when I found this out, I said, do they grade them? Do you get a grade? But let's say on your report, it'll say, for instance, how often do you visit with mother? If you put down, oh, once a year, you're probably going to have a problem. I have a person now I'm talking with. This is the tragic case of the young girl. We're there all day, every day. Okay. When I do them once a week, certain situations, maybe once a month, so they're going to be looked at. And if you get a failing grade, that's going to be brought to the attention of the court, and the court may do something. Or there may be another family member who's saying, boy, she's not doing anything. Let's go in and see if we can get her removed. You can go to court, for anything. When everyone is given notice, the party who's the prospective protected person or incapacitated person is given an in-hand notice. Sometimes they don't even know what it is, but sometimes they read it and it says, if you object to this, you have until, let's say if it were filed today, you have until May 15th to file an objection. And all you have to do is get something to the court saying, I don't want this or I object, and everything grinds to a halt. If you've had to give notice to 10 children, any one of them just has to give a notice and everything grinds to a halt. And mother's probably going to have a lawyer appointed. This stuff can get, I'm involved in a couple of them right now where there's 4 or 5 lawyers, the kids are fighting. Quite frequently, unfortunately, these are cases that involve substantial amounts of money. And the parent is still alive, but incapacitated in the nursing home. One of these, the person is in the nursing home. The other, the person is at home, but she's 100 years old. She's at home, but she has the money to be maintained at home. Right. So, yes, they are enforcing, and I haven't heard of anyone being removed yet for failure to file their reports. So I'm just sort of flipping through here to see if I've forgotten anything. Again, it's still developing. They're still doing trainings. The court all the court personnel went to a training just last week where they're getting updated. I want to put a plug in for our local clerk that does guardianships at the probate court here, Susan Hewitt, was picked as the best clerk in the probate court system in Massachusetts last year. Wow. So at least in Barnstable, we're very fortunate to have extremely knowledgeable and caring people at our court. This is not an urban court like Middlesex or Suffolk that's overwhelmed and drowning in cases. But I'm going to hammer away once again. A lot of lawyers aren't doing these guardianships anymore because they're too complicated, they're too time-consuming. I'm still doing them. I get these cases referred to me. Please do your basic paperwork. Do your power of attorney and healthcare proxy. Then you will control this whole situation. You will be able to dictate who's going to make your decisions for you. If not, you're going to wind up in the court. You want to avoid probate with your wills. Your goal should be to avoid probate during your life also. Because once it's over there, to a certain degree, it's out of your hands, it's out of the hands of even your guardian. And if the family can't agree, or if you have no family, someone's going to be appointed from the court list who doesn't know you. So once again, get those basics done.
And don't assume that just because your children, while you're in your younger years, get along really well, that they're going to continue to get along the rest of your life and their life, because both Arthur's practice and here in our outreach department at the Council on Aging, we have probably 6 cases right now as we speak that have anywhere from 5 to 8 children, none of whom agree on mom or dad's care, all of whom fight with each other, all of whom are trying to get either their own lawyer or taking power struggle. And as Arthur said, most of them evolve around a good sum of money, but a few don't. It's just a total power control. And these were kids that all their lives growing up were perfectly fine with each other and got along really well, and got along really well with mom and dad. But, you know, sometimes when a parent dies and you have one parent left and you feel like you know better than your sister or your brother, you know, if you had these documents in place, it's taken out of their hands and you don't have to worry about that kind of stuff. They can just be your kids. So we cannot together urge you enough to get the basic documents done. You might spend, what, maybe a couple $100 versus thousands and thousands of dollars in court.
That's correct. And what Barbara mentioned is so true that quite frequently, I think 2 seminars ago, I brought my little treasure chest, and when you open it, there's the little house and the little bag of gold. That's what the fighting can be about. But just as frequently, it's strictly sibling rivalry playing out. Mommy loved you better when we were little kids, and now I'm going to get even. And there could be no money involved in those things other than the fees that are flying out, the filing fees at the court, and just the vast amount of time that's involved in putting these things together. I had a situation recently where mother's in the nursing home, and we wanted to sell the house, and we were going to put it in a trust for the daughter because she's disabled. This is something we're going to be talking about in the next session, and we've talked about it before. Then, just like this, a year goes by, and we've got all these reports due. And I was looking at the file the other day. It's about that thick.
Wow.
And this is just guardianship stuff. If the documents had been in place, well, they never would have even seen me. They could have done everything else. So if we don't have what you're convinced now, I don't know what we can do.
My last question is,
Sure.
Are all elder law attorneys aware of all of these documents?
All elder law attorneys are definitely aware of these basic documents, because that's basically what they do. Guardianship, some lawyers don't like going to court, and some lawyers don't do this. Some elder law attorneys may just do mass health applications. But since the new law went into effect, lawyers that used to do a lot of this aren't doing it anymore because they just don't want to be bothered with all the paperwork. And every time I do something, I have to call over to our very helpful clerk, and she'll tell me, you know, you have to file the following. And I'll have my pen, and by the time I'm done, I'll go, there's 8 things here, okay? So a lot of lawyers don't want to be bothered, but an elder law attorney or anyone calling themselves an elder law attorney definitely is aware of these basic documents, and they're aware of how they impact you both if you have them and more particularly if you don't have them.
Well, thank you very much. Once again, obviously a mound full of information. We will have it available on DVD as always. You can either ask here at Channel 18 or in our Council on Aging. We always have a lending library. Thank you for tuning in.